Had a conversation with a family yesterday who is choosing not to name their children as beneficiaries of their estate. And you might wonder, why would somebody do that? That relationship must be so fractured. Well, not necessarily. You see, in this case, the parent has gifted their child a significant asset while they are alive. In this case, they bought a house for them, and it's not just a small starter home. I mean, this is a big piece of real estate worth 7 figures. Now, that brings up some tax issues. We can talk about that in another video. But from the parent's perspective, they're thinking, our child has already benefited a great deal. And so when we pass away, we want the remainder of our assets to go to our grandchildren. We're going to skip over our child and go to the grandchild. Now, that too brings up some tax issues, which we'll address later. There's other scenarios where you might choose to not name a child in your will or your trust. What if that child is going to benefit through another avenue? Maybe they're a beneficiary of a life insurance policy. So the life insurance policy may benefit the child directly, and maybe the assets in the estate, those controlled by the will or the trust, may benefit somebody else. Or what if everything is going to charity? The family's on great terms, but the parents decide that everything we have is going to go benefit particular charity or charities. And there's always the scenario, and perhaps it's the one that you thought of first, that relationship is so fractured and strained that the parent just chooses not to name the child as a beneficiary. In whatever the scenario may be, if you're going to disinherit somebody, and I know that word carries some strong feelings, but if you're not going to name them in the will or the trust, you need to make it very clear in the document that you are doing this on purpose and with intention. Because by making it clear in the document, that takes away the argument, or at least weakens the argument, that somebody may claim that this was a mistake, or that you were unduly influenced by somebody else and that you didn't really intend to do this. So make it clear in the document that you are doing this on purpose and with full knowledge of your actions. I also encourage you, have some communication. Maybe that's a verbal conversation. If there's a good relationship with your child and they're not going to be named as a beneficiary of your will or your trust, have a conversation about it. That way the two of you can converse back and forth. They can ask questions, you can provide answers, you can provide the rationale, what you're thinking as to why you're doing this. Or if a verbal conversation isn't a possibility, consider putting that rationale in writing. Now, I would caution you, probably not best to include that rationale in the will or the trust because those documents are going to be read by other persons, but maybe you can choose to do that through a written letter. And maybe it's in a sealed envelope that's delivered to your child with the rationale included by the executor or the trustee. And that way you can communicate what your thoughts are without sharing that to everybody around. So in summary, you can disinherit somebody. There are multiple reasons why that may be worthwhile. Make it really clear in the document and consider communicating the rationale as to why you're doing that.